So let's talk about this like legal analysis that the UK released on why, according to the UK, there is no genocide, which is like, okay, it's the people who are funding and giving weapons to genocidaires are telling you that there's no genocide is okay, very reliable information, like super non-suspicious at all that this happened, right? So um I feel like there's a lot of misinformation on how to detect yeah, small conflict of interest, says Jartov. And there's a lot of misinformation on how to detect genocide, how to apply the law. That's actually one of the videos that I want to make on the only reasonable inference test. And so let's look at what the government said, because the government in the UK said something even worse than that disinformation about the only reasonable inference test. Let's look at it, okay? Oh, hey, Magic, thank you so much for the 100 bits. So it says, well, I'm gonna skip the whatever. So yeah, they condemn E1. Let me. I don't know if you guys can read this. Oh, this is too much. Sadly, I cannot make it bigger. I think. Oh yeah, I can. Okay, cool. So it says that the UK is not arming Israel's war in Gaza. As you know, one of our first acts in government was to review and suspend export licenses that may be used by the IDF in the conflict in Gaza. We have successfully implemented the suspension announced on 2nd of September 2024 and continue to refuse all such license applications as set out by Parliament. The only exception to the suspension is exports to the global F-35 program. Yeah, but see, it's F-35 started doing the bombing. So, wait, did we get to level 3? Holy crap! Dick Penderin, thank you so much for subscribing. I appreciate that. Wow, we are this has this ever happened? I feel so Hassan Piker right now. So yeah, level 3 hype train. Appreciate that. Iconoclast, thank you so much for your 100 bits. So we are facing a critical moment, says the letter, for European security and war in our continent, and the government has a duty to consider the full implications of all armed exports decisions. The F-35 partnership is the largest defense program in the world with over 1,000 F-35 aircraft in service globally. It is being used by every day to keep Allied airspace secure and deter Russian aggression. Undermining the program would significantly disrupt international peace and security, NATO deterrence, and European defense. It is for that reason alone that we took the decision to continue exporting to the global program. However, as we announced last September, we have stopped direct exports of F-35 parts for use by Israel. I mean, I guess that's good. As you asked several detailed questions on how continued exports of the global F-35 program are consistent with international law, for which answers are provided below. I also note that the government's legal position on these was set out in detail in the skeleton argument for the recent Al-Haq judicial review, which was shared with the blah blah blah. So the question here is, does the government accept that the duty to prevent genocide has been triggered? If so, at what point was this duty triggered? If not, why not? Guys, we made it to a level 3 hype train. Congratulations, everyone. Thank you so much. I really appreciate it. So question 2, if the government accepts that the duty to prevent genocide has been triggered, what steps is the UK taking to employ all means and do all in their power to prevent genocide as far as possible? Question 3, how does the exception for F-35 components comply with the duty to prevent genocide? And they say, government's position is covered in detail in paragraphs 87 to 101 of the skeleton argument for the Al-Haq judicial review. The duty to prevent genocide under Article 1 of the Genocide Convention arises when the UK learns, or should normally have learned, of the existence of a serious risk of genocide. From that moment on, if we have available the means likely to have a deterrent effect on those suspected or preparing genocide for reasonably suspected let me read that again. From that moment on, if we have available the means likely to have a deterrent effect on those suspected of preparing genocide or reasonably suspected of harboring genocidal intent, the UK is under a duty to employ all means reasonably available to us to prevent genocide. This position is in line with the decision of the ICJ in the case concerning the application of the Genocide Convention, Bosnia v. Serbia. The government has carefully considered the risk of genocide, including when permitting exports to the F-35 program. The high civilian casualties, including women and children, and the extensive destruction in Gaza are utterly appalling. Israel must do much more to prevent and alleviate the suffering that this conflict is causing. okay, what exactly should it do? Right? What is it doing wrong? Would be nice to hear from the UK. What it's not enough to say whatever Israel is doing, too many women and children are dying. No. Uh, tell us what is it that you think they are doing wrong. The reason why they cannot do that is because if they say, oh, I mean, their targeting standards are terrible, then what they are saying is they're committing war crimes and violating distinction or proportionality. So they cannot actually tell you what they're doing wrong. So this is just not very good. As part of the Genocide Convention, the crime of genocide occurs only when there is a specific intent to destroy, in whole or in part, a national, ethnic, racial, or religious group. The government has not concluded that Israel is acting with such intent. Why not? So the last paragraph says, as you highlight, the ICJ is considering a case brought by South Africa against Israel under the Genocide Convention and has ordered provisional measures, including on humanitarian access in Gaza. Israel is under an obligation to implement such measures as a matter of international law. The UK has repeatedly recognized the horrors of the conflict in Gaza. What horrors? Again, which acts are the illegal acts? And what can Israel do to not commit such illegal acts? That's what you need to be saying here. We're way past generalities here. The UK has repeatedly recognized the horrors of the conflict in Gaza and has called upon Israel to comply with the court's orders. The case is ongoing and the court is yet to hear and rule on the merits. To date, the ICJ has neither found that Israel has breached its obligation under the Genocide Convention nor ruled on the plausibility of Israel committing genocide. Accordingly, we do not consider that the ICJ's provisional measures order should be regarded as creating an awareness of a serious risk of genocide. This is not how it works. There's a lot of it's amazing to me how fairly obvious points have been obscured by the Hasbara, by Israeli talking points. Because when you give a provisional measures order, it sort of does mean that whatever you're doing might cause what the other party is saying you might be doing, right? So provisional measures orders are meant to prevent the case from harming a party that might actually win in the end, right? So say, for example, that you want to construct a dam in a river, and that river is, once dammed, is going to flood areas that belong to someone else. And that person says, I'm going to sue you so that you don't construct the dam. And then that person files provisional measures before the court and says, court, if the dam is built, right, my lands will be flooded. Therefore, I want you to issue provisional measures so that the dam isn't built while we're in process, while we're in this procedure. Meaning, therefore, that if the court, for this person to win on the provisional measures argument, they would need to show that there is a plausible risk, right, that his lands would be flooded, right? So for you to prove that there's a plausible risk that your lands will be flooded, then plausibly the dam will flood your lands. You see, it's correlated. This is pretty standard legal thinking. Like I mean, I don't understand why this is a problem. I really don't get why this is a problem. It shouldn't be a problem. This isn't how it like this isn't the mystery, right? And so the court would issue an injunction or an order or whatever you want to call it and say, do not build the dam, because if you build it, you might flood their lands. And then what happens if 2 years later he wins the case, but his lands are already flooded? So to win on the provisional measures order, the other party would need to argue that there is really no risk of the lands being flooded. Because, I don't know, maybe the dam is not going to actually impact that part of the river and they can show it. Or they can show that they can, I don't know, whatever reason, right? But once the court says, no, yeah, provisional measures, do not build the dam because you might flood his lands. It's the same in the context of Gaza. So South Africa is saying that the rights of Palestinians not to be genocided under the Genocide Convention are plausibly at risk of irreparable harm. Meaning that if South Africa is saying you are committing genocide, and then Israel carries on with what it's doing, and then the court 7 years later declares, oh, it was a genocide. What South Africa doesn't want is then look back at Gaza and say, oh, whoopsie, but there are no more Palestinians in Gaza because they were genocided, right? So the point is, if South Africa wins, South Africa doesn't want a genocide to have happened. So in order for South Africa to win in the provisional measures stage, it needs to argue that the rights of Palestinians under the Genocide Convention are plausibly at risk. Plausibly at risk of what? Of genocide, right? So there's a lot of like obfuscation going on about that, particularly because of Joan Donahue's interview, saying like, oh, we did not say that there's a plausible genocide. We said that the rights of Palestinians, like the ICJ, the rights of Palestinians not to be genocided are plausibly at risk. So plausibly, what Israel is doing might genocide Palestinians. It's that simple. So on that point, this letter is off already. But there's more, right? Because, okay, even if you believe that that's the case, that the provisional measures order does not really determine that there is a plausible genocide. The very existence of the provisional measures says that rights under the Genocide Convention are at risk. However you want to reframe it, however you want to international Hasbara law this into it not being a quote-unquote plausible genocide, it is still an official judicial determination that rights under the Genocide Convention are at risk. So this, we do not consider that the ICJ's provisional measures order should be regarded as creating an awareness of a serious risk of genocide. I don't know what lawyer wrote this, but that is a terrible sentence. Obviously, the provisional measures order creates awareness of a serious risk of genocide. That is the purpose of the provisional measures. To say there might be a genocide going on here, so stop what you're doing so that you don't end up committing it. Right? Or at least don't do it in this way that might end up causing a genocide. Don't starve the population, don't go into Rafah, like, comply with the Genocide Convention. Of course it creates awareness. It's irrefutable that it does. Right? So, and this argument that no, until the ICJ rules on the merits, we cannot know if there's a genocide or not, is stupid. Because by that argument, then we cannot really know that Sudan is a genocide, because the court has not ruled whether Sudan is a genocide or not. That would be stupid. That would mean that first you genocide, and then you see if whatever you did was genocide or not. What is the point of that? What duty of prevention works that way? No duty of prevention works that way. You have a duty to prevent while the genocide is ongoing, not after it's done. This is silly. Jartov says, are there punishments listed somewhere for violating ICJ orders or the Genocide Convention? There are, but you're not going to like them. So enforcement of the ICJ decisions are entrusted to the Security Council. And so the US has a right to veto whatever enforcement mechanism the Security Council wants to choose to force the state to comply with the ICJ's decisions. Yeah, exactly. So, yeah. International justice is a complicated thing. What can I tell you? So this determination is quite frankly very, very bad.